The architecture of American democracy is not merely cracking, it is being actively, violently dismantled before our eyes. We are witnessing a moment that future historians, if there are any left to record it, will mark as the definitive point of no return. It is a convergence of executive lawlessness, judicial defiance, and congressional theater that signals the final, gasping collapse of the system of checks and balances that we were taught to revere. When a cabinet secretary can look a federal judge in the eye and effectively say, "Your orders do not apply to me," and then turn around and treat the United States Congress with the petulant dismissal of a monarch, we have ceased to be a nation of laws. We have become something else entirely, a mafia state where power is its own justification and accountability is a fairy tale told to the powerless to keep them docile. Welcome to this report. I am Chris Hedges. Today on Chris H. Media, we must dissect a spectacle of governance that reveals the profound moral rot at the heart of our imperial capital. The Secretary of Homeland Security, an official sworn by oath to uphold the Constitution, finds herself in a crisis of unprecedented magnitude. But do not be fooled by the partisan bickering you see on cable news. This is not merely a political scandal. It is a constitutional stress test that the Republic is failing. A chief judge in the D.C. Circuit is currently weighing whether to do the unthinkable, find a sitting cabinet member guilty of criminal contempt. Let that sink in. We are not talking about a civil infraction. We are talking about criminal contempt. The judge is considering referring her case not to the Department of Justice, which has been captured and neutered by the very administration she serves, but to an independently appointed prosecutor. Why has it come to this? Because the Secretary allegedly authorized the deportation of roughly 200 human beings to El Salvador in direct, willful, and arrogant violation of a federal court order. These individuals were not merely sent home. They were knowingly sent to a facility that human rights organizations, legal observers, and international bodies have described as a torture chamber. This is a violation of the most basic tenet of human rights, non-refoulement. To send a person back to a place where they will face torture or death is a crime against humanity. And yet this administration, draped in the rhetoric of liberalism and law, did exactly that. They did it because they believed they could. They did it because they believed that the edicts of a federal judge were mere suggestions, obstacles to be circumvented by the brute force of the executive branch. Simultaneously, we saw this same official appear before Congress, not as a servant of the public, but as an adversary of the truth. The questions posed to her were deceptive in their simplicity. They required only a yes or no. Yet what we witnessed was a display of obfuscation and arrogance so profound that the chairman of the committee was forced to threaten perjury charges. This is the new face of American governance, a fusion of incompetence, malice, and impunity. The specific issue at hand in Congress, the tragic shooting of National Guard members by an Afghan national, is being used as a political truncheon. But the underlying reality is far more sinister. We have a government that grants asylum to those who serve the machinery of empire abroad only to use them as props in domestic political theater when the blowback arrives. In this series, we will strip away the noise. We will look at how the executive branch has decided that the judicial branch is no longer a co-equal power, but a nuisance to be ignored. We are watching the birth of what the political philosopher Sheldon Wolin called inverted totalitarianism, a system where democratic institutions exist in name only, hollowed out from within by a corporate ruling class that recognizes no authority but its own. The Secretary of Homeland Security is not an anomaly. She is a symptom. She is the personification of a system that has severed itself from the consent of the governed and the rule of law. Stick with me, because what we are about to uncover exposes the terrifying reality of who really runs this country. Let us turn our full attention to the federal courthouse, for this is where the true battle for the remnants of our democracy is being waged, far away from the cameras of the congressional hearing rooms. The media focuses on the shouting matches in Congress because they are entertaining, they are designed for sound bites. But what is happening in the courtroom of the Chief Judge of the D.C. Circuit is existential. It is quiet, it is procedural, and it is deadly serious. The facts are chilling in their clarity. On a specific evening in March, a federal judge issued a binding order. He commanded the Department of Homeland Security to halt deportation flights to El Salvador. This was not a suggestion. It was not a recommendation. It was a check on state power, a legal firewall designed to prevent the irreparable harm of sending individuals to a prison system notorious for its suspension of due process and basic human dignity. And what did the secretary do? She ignored it. The planes took off. The engines roared, the wheels lifted, and human cargo was delivered to the regime in El Salvador. This act raises the most terrifying question a republic can face. What happens when the men with guns, The executive branch simply stopped listening to the men with robes. The foundation of our entire legal order rests on the assumption that court orders will be obeyed. If the president or his secretaries can simply decide which laws to follow and which to ignore, we are no longer a republic. We are a dictatorship in all but name. The administration's defense is the classic refuge of the scoundrel. Advice of counsel. They claim lawyers told them they could proceed. But this defense is a hollow shell, a transparent lie. As the judge's ongoing evidentiary hearings are revealing, this was likely not a case of legal confusion but of calculated defiance. They didn't misinterpret the law. They shopped for the legal opinion they wanted. They sought out lawyers who would tell them what they wanted to hear, who would provide a thin veneer of legality to cover their naked authoritarianism. They essentially asked, "How can we do this anyway?" and found a lawyer willing to say, "Go ahead." The judge is now taking the extraordinary step of personally conducting witness examinations. This is rare. Judges usually let attorneys ask the questions, but this judge realizes that the normal adversarial process has broken down. He is hauling in whistleblowers from within the Department of Justice itself, career attorneys, people who have dedicated their lives to the law, who looked at this lawlessness and said, "No." These are the people the system usually crushes, but here they are the witnesses to the crime. The judge wants to know who gave the order, who signed off on defying a federal court. The administration wants to sweep this under the rug to refer it to the Department of Justice where it can die a quiet death. But the judge knows that the DOJ is conflicted. How can the Justice Department investigate the very administration that controls it? If the secretary is found in criminal contempt, it will be because the court has recognized a singular truth. The administration believes it has achieved executive supremacy. They believe that the president's will supersedes the judiciary's command. This is the hallmark of dictatorship draped in the banal language of bureaucracy. They are not arguing that they complied with the law. They are arguing implicitly that the law does not apply to them when it is inconvenient. The judge is standing as the last line of defense. If he blinks, if he allows this to pass without severe consequence, the precedent is set. Future administrations will know that court orders are optional, and when that happens, the concept of rights becomes meaningless. Your rights only exist if a court can enforce them. If the executive branch can ignore the court, you have no rights. You only have temporary privileges granted by the state, which can be revoked at any moment. While the courts grapple with the corpse of the rule of law, Congress has descended into the theater of the absurd. The Secretary's appearance before the committee was a masterclass in evasion, a grotesque display of the contempt in which the ruling elite holds the elected representatives of the people. The question asked by the chairman was deceptively simple, a question that cut through the fog of bureaucratic language. Who approved the asylum for the individual responsible for shooting National Guard members? This is where the bipartisan complicity in our imperial wars comes home to roost. The perpetrator was not some random wanderer. He was an asset. He worked with U.S. military and intelligence services in Afghanistan. He was a tool of American hegemony, a cog in the machine of occupation. And when that hegemony collapsed in Kabul, when the empire retreated in humiliation, he was brought here. The current administration wants to blame the previous one for his vetting. The previous administration blames the current one for his final approval. They toss responsibility back and forth like a hot coal, while the victims, the National Guard members, are forgotten props in their argument. But watch the Secretary's behavior. It is a study in arrogance. When pressed on who signed the paper, a factual question of administrative record, not a matter of classified intelligence, she refused to answer. She offered contemptuous glances, sarcastic deflections, and bureaucratic word salad. She acted as if the question itself was beneath her dignity. Why? Because the truth is inconvenient. The truth reveals that the national security state is a bipartisan enterprise that vets its assets based on their utility to the empire, not their safety to the public. To answer the question would be to admit that the system failed, that the thorough vetting we are constantly promised is a lie. And then, the moment of ultimate disrespect, a moment that should enrage every citizen. The secretary, under oath, claimed she had to leave for a critical meeting. She simply decided she was done. She stood up and walked out on the people's representatives. We now know this meeting was a fabrication. It had been canceled. She knew it was canceled. She used a lie to escape accountability. Think about the arrogance required to lie to Congress about a scheduling conflict to escape questioning. It is the behavior of a ruling class that views oversight as a nuisance, as something to be managed and discarded. The chairman's threat of perjury is not hyperbole. Perjury is not just lying. It is the deliberate intent to mislead. By evading the question of who authorized the asylum and then lying about her reasons for fleeing the room, the The Secretary has demonstrated that she views Congress not as a co-equal branch of government, but as a public relations annoyance. This wasn't a misunderstanding, it was a strategy. It is the strategy of the stall, the strategy of running out the clock. They know that the news cycle moves fast. They know that if they just refuse to answer, the media will eventually move on to the next shiny object. But we must not move on. We must linger on this image. A cabinet secretary, fleeing a hearing room, hiding behind a fake meeting to avoid telling the American people who let a shooter into their country. This is the definition of cowardice. What we are witnessing with the Secretary of Homeland Security is not an isolated incident. It is not an anomaly. It is the inevitable result of a political system that has severed itself from the moral and legal tethers that once bound it. We are watching the grand finale of the American experiment. We have a cabinet official facing criminal prosecution from the judiciary and perjury charges from the legislature simultaneously. In a functioning democracy, in a sane society, this would trigger immediate resignation. It would trigger systemic reform. It would be on the front page of every newspaper, the lead story of every broadcast. But in our system, our inverted totalitarianism, it triggers nothing but more spin, more polarization, and more power consolidation. The system protects its own. The Secretary knows what every member of the elite knows. Impunity is the currency of the realm. They believe they can ride out the storm because the institutions designed to hold them accountable have been hollowed out. They rely on the Department of Justice to protect its own, to act not as the people's lawyer but as the president's shield. They rely on the media to turn legal questions into partisan squabbles, ensuring that half the country will defend them no matter what they do. But the judge in the D.C. Circuit offers a glimmer of resistance, perhaps the last glimmer we have. By considering the appointment of a special prosecutor, he is attempting to reactivate the immune system of the Constitution. He is asserting that no one, not even a secretary carrying out the president's orders, is above the law. This is a radical act in 2025. To simply apply the law as it is written has become a revolutionary act. If we lose this battle, if the executive branch is allowed to ignore court orders and lie to Congress without consequence, then we have entered the final phase of imperial decline. We are left with a naked power structure, unburdened by law, unresponsive to the citizenry, and protected by a praetorian guard of lawyers and spin doctors. The Secretary's arrogance is a mirror. It reflects a governing class that has lost its fear of the people and its respect for the law. And history, brutal, unforgiving history, tells us that when the rulers lose their fear of the law, the people must eventually rediscover their power to resist. We are standing on the precipice. The question is no longer whether our government is corrupt. The question is whether there is any mechanism left to stop it. The Secretary's walkout was not just an exit from a room. It was a symbolic exit from the social contract. She walked away from her duty, from the truth, and from us. The question now is, what are we going to do about it? This is Chris Hedges for Chris H. Media. We will continue to follow this trial. We will continue to expose the lies, and we will not let them look away. Thank you for watching.